Yes, Springtime for Hitler. And of course, in the plot, the play is a huge success, which is a problem for the con men because they can't pull their con if the play succeeds. And Vinco isn't quite there yet, but Vinco is kind of a stock market version of the producers because Vinco has, in theory, a tremendous future and could be an extremely profitable company if it were operated by fiduciaries who have the company's best interest and not their own self-dealing interest in mind. And if they were operating the company and if they had been developing their major assets like Lemotif and Adriser, instead of acting like spoiled children in a toy store, buying toys and going home and not even playing with them and then going back to the store and buying more toys until they've used up all the money and can't afford to buy any toys anymore, and then the toys are obsolete and so everybody loses. What this company is doing is, and I understand more than probably anybody in this courtroom, as having been a criminal defense lawyer my entire career, which spans 45 years, that everybody is presumed innocent unless and until proven guilty, and that hasn't happened with Mr. Farnsworth yet. That's the operational work. Now, counsel made a point that I want to address when she said that she incorrectly suggested that that the federal government had looked into Vinco and Zash and 360 and Icon Publishing and everything, and they had basically vetted it and approved him to do the work. I can tell you, having reviewed Pacer and having an intimate knowledge of how those processes work, that that's not what happened. What happened was, and when we talk about page 7 of the special conditions of, and there's really 3 conditions to Mr. Farnsworth's bond. There's the general conditions, there's the special conditions, and there are hidden conditions that only the parties can see. I'm not going to speak to why that is. I know why that is, but it's not relevant to these proceedings, so I'll move on from there. But when you look at page 7 and you look at it starts with a paragraph that talks about what Mr. Farnsworth cannot do. And it lists he can't transact securities and this and that and the other thing. And then at the end of that first group of thoughts, instead of a period, there's a comma, and then it says except, and then it goes into the exception and allows him to transact with Zash, with Vinco, with 360, etc. And what I know happened was that Ted's lawyer in that case asked for that exception in the bond, and the U.S. attorney agreed to it, and so the judge approved it. But the U.S. attorney, there's no evidence that the U.S. attorney actually vetted it before they approved it. They very well may have just taken Mr. Farnsworth's lawyer's word on why he said he wanted that. I can't really go beyond that at this point, but I can tell you that it is absolutely, there's no evidence, nor could there be at this point, to support counsel's allegation that the government vetted it and then approved it, because that's what I heard her say. And the only thing that we can say for certain is that the government approved it. We don't know if they vetted it. And in all likelihood, knowing how these things go, I can say with certainty that I'd be shocked to find that the judge himself vetted it. And I would be pretty surprised, just to say the least, to find that the United States attorney or any of their deputy attorneys would have vetted it, but rather that there was a conversation dealing with the terms of the bond, which took place rather quickly when Mr. Farnsworth appeared on the citation to come into court to surrender and post bond and such. And the other thing that was alluded to but not actually articulated as thoroughly as it should be is that Theodore Farnsworth and Roderick Vanderbilt, who sits currently as the chairman of the board for Vinco, they're partners in business, but they're also partners in life. And when Mr. Farnsworth had to post a bond, and I'm not judging, that's not the point. The point is that you got Mr. Farnsworth, who at least is being, the government is being circumspect about his dealings in the stock market and his track record that anybody can see by investigating and looking at the internet for all of the companies that he's had is less than admirable in terms of securing positive performance over long term. On the contrary, his track record for every company is that it starts with a lot of money being raised and a lot of money going to him and then everybody else losing. And his modus operandi is to pay himself and nobody else. Now, I'm not going to get into the Jason Ma and Vincent Buddha lawsuit that's also before this court, but that has to do with vendors not being paid. So while Mr. Farnsworth is going to get his transaction fee, his finder's fee for each of these items, which he always has, and then he's going to retain ownership, and you've heard about that. That's what they're trying to do next. In other words, they got money for Lemotif, and they blew through it. They got money for AdRiser, and they've blown through it. And now they want to acquire the Inquirer and get money for it, and then blow through it. And ultimately, what you have is a situation where a company that could be a huge success, but for the fact that the board members are not staying true to their fiduciary duty, and they're engaging in self-dealing. So, for instance, one of the ways that money has gone out is they created a company called, how do you pronounce it?
Magnify You.
Magnify You, and which is a private company, and it's all the bills for Magnify You are paid by Vinco. But Vinco doesn't get, but what's percentage?
I believe it's 15%.
15% of the profits. So Vinco pays all the expenses, but only gets 15% of the profits. And who works for Magnify You? All of Lisa King's family. So
Lisa King's the founder.
And she's the founder. So Vinco loans a bunch of money to Lisa, and then they start this company, which is not publicly traded, and Lisa employs all of her family, and Vinco pays all of the expenses and takes very little of the profit. And that money that's being paid to operate Magnify You and to pay the family and to give them the leased cars and the increased benefit, and the benefits are pretty significant, a lot of money going out, that's shareholder money. And that's how this whole thing is. You get the money from the shareholders by diluting the stock, and then distribute the money to Ted and his friends, and then to find another project to raise some more money and ask for more dilution, and then distribute to their friends, and keep doing rinse and repeat, fill the piggy bank, empty the piggy bank until you can't fill it again, and then take the empty piggy bank and file bankruptcy. That's his MO. It's a very clever scheme. I like Mr. Vick, I didn't want to be here. I didn't want to be a plaintiff. I certainly don't want to be in court arguing about this. We tried very hard to find a lawyer. I have a fool for a client. There's no mistake about that. I'm a fish out of water here. My experience in court is vast. My experience in corporate is zero. My experience in civil is very small. And so if you want to have a competition about Nevada statutes between me and any other counsel, I'm going to lose that. If you want to have a competition about what is required to dot the I's and cross the T's in corporate law, I'm going to lose that. But what I do know is that as a metaphor, my investment is on a bus that is headed off a cliff. And everybody on this bus, family men like Mr. Vick, people like Muntz, have put a lot of money into this company in good faith, believing that the company would succeed and that their investment would prosper as a result of that. And after 2 years of watching the stock price go down, 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 for me, 98%. 98%. I can't afford to lose that. I'm hoping to make that money back so that I can use it to pay taxes that I owe. I can't afford to lose it, and I'm about to lose it. And we couldn't find a lawyer in time to take the wheel to avoid this corporate bus from driving off a cliff with our money and everything being lost. So out of desperation and for no other reason, I told Mr. Vick, I said, I don't want to be on this case. I've had enough. And I said, and frankly, I have baggage. It's no secret. This counsel has made a point of it. I don't need to repeat it, but I said that baggage is not something that you guys should be saddled with. But if nobody's going to take the wheel, and this corporation is going to drive off the cliff with our investment, and our last few pennies are going to be lost, instead of having at least a prayer of saving that company, and it's savable. I know, for instance, with Lemotif, if Lemotif was developed properly, it could fill the void for TikTok if TikTok or when TikTok gets taken off. I know that Mr. Vick could build the Lemotive platform, and I'm not saying he should, but I'm saying just he could build that Lemotive platform to the point where it would be as good or better than TikTok, and it would take him no more than 6 to 8 weeks, probably less. So it's not like we couldn't get up to speed. It's not like we couldn't bring the stock price up above $1. It's not like we couldn't do all of these things and save this company. But the people that are driving this company right now don't want to do that. And so we're like the only people that were able to get this in front of a judge, as we are today, as a Hail Mary, if you will, and say, give us a moment. Now, counsel talks about what is the harm, okay? While she was talking about that, I had an idea as to a response for that. The harm for the company is that it would be delisted. And if we were to take counsel at her word that her clients don't want that to happen, and let's assume that that's true arguendo. I don't believe that to be true for a minute, not even for a second, not even for a New York second. However, let's assume that it is true. Could they do it? Yes, they could. They're not doing anything that they should be doing in order to accomplish that. One simple step would solve that problem. If they really were honest about wanting to save this company, they could voluntarily ask NASDAQ to halt trading of the stock in lieu of being delisted. They could hold their shareholder meeting, which is one of the things that they're in deficit of. And because they would be in halt, then the rule having to do with being below $1 and all of that, that would be suspended. It would be abated for the moment. And we could begin to see some action that would be consistent with the lip service that they're actually trying to do something. As Mr. Vick has said, we don't have current financials. Now, I'm going to ask you a question. If you were, let me ask it a different way. I don't want to make it personal. If a person were an owner of a company that's publicly traded and they were being asked to make a decision about a significantly sized investment, and that decision was financially based, in other words, you're being asked to do something to raise money or to cut costs or something, do you think that it would be important for that person, in order to intelligently exercise their vote, that they would have proper, up-to-date, and accurate financial statements so that they could utilize that information in order to make an intelligent decision about whether to vote yay or nay on each individual item? I happen to think that anybody who would be asked that question would say, I would really like to have that information before I exercise my vote. In fact, let me take it a step further and say that I could not intelligently exercise my vote without that information. And that's the position that we're in as shareholders, is they're asking us to make some very important decisions about huge financial transactions, such as buying the National Enquirer. And we don't even have the financials to know whether or not they could even complete the deal. What we do know is they have enough money to pay Ted's finder's fee. What we do know is that if they were put into Chapter 11 receivership right now, and I'm not saying that's the solution, I'm not saying that's what we're asking for, I want the company to succeed. But if they went into Chapter 11 right now, there's enough cash in the company to make the common stock shareholders whole, and my understanding, could be wrong, my understanding is that we would be preferred creditors. And so I see again counsel shaking her head no, and whether she realizes it or not, that does break my train of thought. So I would ask that I won't do that, and if the court would please, consider asking counsel not to do that.
I'm not going to let anybody act out. I know what the law is on this stuff, guys.
Okay, so in any event, what I'm saying is this. We don't want the company to fail. We don't want to do anything to hurt the company, but we don't want the company to hurt us. And as between us and them, the empirical evidence is overwhelming that they have gone out of their way to treat us as though we don't count. They don't want to talk to us, they don't want to know about us, and they don't want to release any information. And I suppose you could say it's pure speculation, but there's been no press releases about anything until this lawsuit was filed. And then all of a sudden, it's one press release after another about all the wonderful things that they're doing. You know what the telling thing is, though? With all of these press releases, normally in the stock market, when a company issues a press release about something wonderful that they're doing, you can see evidence of it in the stock chart. You can see the stock price going up. You know what you see when you look at the stock chart for Vinco over the last few days? The stock, three things actually. The first thing that you see is that the stock price hasn't gone up. The second thing that you see is that the volume of stock that's trading is relatively nothing. Like when this stock was trading heavily, when it was at its all-time high, and the price hit, I think, $12.49. It's about 2 years ago.
300 million.
300 million shares a day. Today, the last time I checked, we had traded under 3 million shares. The third thing that you'll see if you know how to read TA on a stock chart is there's a thing called on-balance volume. Now, normally when a stock price is depressed and it's going down, the on-balance volume looks a certain way. When you look at the on-balance volume of the stock chart for Vinco Ventures for the last year and a half or two, the on-balance volume tells a completely different story than the stock price. Completely different. If we were to go on the on-balance volume, we would be at an all-time high right now. Now, again, we're not here to talk about dark pool trading. We're not here to talk about conflict of interest for market maker. We're not here to talk about any of that. But there are reasons why this stock is going from very valuable to worthless. And it hit critical mass where we're almost at worthless. And that's why we're here. We've tried everything that we could think of as intelligent investors to try to become engaged with the company in order to find a path forward that would be good for them and good for us. And all we've gotten is being treated like the unwanted red-headed freckled stepchild at the family picnic. That's it. And so when we got to that point, and when Mr. Vick and 3 or 4 other shareholders tried to put shareholders onto the ballot so that the stockholders would have an option and decide who might they like to be on the board, the company that couldn't get anything filed on time, that couldn't hold meetings on time, that couldn't do anything on time, that when they did file with the SEC on their 10Qs and their 8Ks and all of that they cut and paste and they had the wrong names on them. That this company can't seem to do anything right, but when they don't want us to get ahead in a way or get in their way, they can crank out a 10-page letter pointing out all of our deficiencies. It wasn't mine, I wasn't part of that, but could point out all those deficiencies very quickly. And then when a court case is filed and they're faced with an impending TRO that rains on their parade, they can bang out press release after press release after press release. And one of the press release lines was this thing about the acquisition of the Inquirer, which requires a shareholder vote. And it's one of the items that's on that list. I forget which number it is, but it's between 2 and 10. And they're asking us to approve that purchase. But if you look at the news releases, starting with the article that came out in New York about 2 weeks ago, Ted Farnsworth is in press saying, we've already closed this deal, I'm already operating this company, and we're doing this and we're not doing that, and we're not going to cover the Trump trial and so on and so forth. He's talking about it like the deal is done. And from what we can tell, that may actually be the case. The checks may actually have been written in cash, but the shareholders haven't voted on it yet. Now, why would they do that if they didn't think that they had the vote? And how could they have the vote when the Main Street investors, of which Mr. Vick and myself and Mr. Muntz are the current face of in this courtroom, although we don't represent other people, it's not a class action lawsuit, the face of the Main Street investors owns, and again, talking about the Big Family website, the Main Street investors own somewhere about 81 to 85% of the common shares of this company. We're the major shareholders of this company collectively. Earlier, when Ms. Stein was talking, she mentioned something that had to do with if you did it right and you had a certain percentage, I think it was 10 or 15%. And we have way more than that, but we don't have enough to override the preferred shares 51% supermajority vote, which should have never happened because we've never approved it. And we're coming up on a meeting in a couple of days where they're going to exercise those shares, even though they were illegally issued. And once those eggs are scrambled, we'll never be able to unscramble them because here's what's going to happen. They're going to have the meeting, they're going to hold the vote, they're going to pass the resolutions that they couldn't pass last year when they had the meeting and canceled it because they knew that they didn't have the vote and they didn't have some sort of workaround mechanism to create the vote out of whole cloth. And so now that they've created that, they want to rush forward. And we're in a position where if they get that, we get a reverse split. The stock price comes up above $1, and then they push that deal through, and they get the 360 deal, and Ted gets paid yet again, and then we watch the stock price go down, 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 and we get back to this point, and then mark my words, you're going to look at this company. If you don't grant this injunction, at least in some incantation, in some form, then you're going to look at this stock one day, a year or two from now, and you're going to think, hey, I wonder whatever happened to BBIG, that case that I had in my courtroom. And you're going to open it up and it'll go, oh, they got delisted. They went bankrupt. And I'm not going to speak to what else you're going to see in other courts outside of the Nevada court and outside of civil courts, but you're going to be thinking about what you heard here in this courtroom today 2 years from now, and you're going to look at it and you're going to go, wow, Mr. Vick was right. Mr. Muntz was right. Mr. Jennis was right. And the only thought I have to ask to you is, if there's a legal mechanism whereby you can find the way to protect the company, which we want, I don't know how many more times I can say this or how I can say it better. We don't want to harm the company. Our money is in that company. If that company is harmed, our investment is harmed. We want this company to succeed. What we don't want is we don't want insiders that are engaged in insider
Collusion.
no, what's the thing I looked up today? The dealing.
I'm sorry.
I'm going to say insider dealing for lack of better description, where they're trading our money back and forth between these different companies, and they're violating their fiduciary duty. We want that to stop. We want people that actually know how to run a company successfully and can be fiscally responsible with expenditures and purchases and product development, and that if they, let me just say it this way. I had no idea that these offices were empty buildings. If I had the ability to travel to the locations where this company supposedly is doing business and all of their subsidiaries are doing business, and I went to the front door and saw that the door was locked and the office was empty, would I invest in that company? Would anybody in this courtroom invest in a company if you went to the corporate headquarters and found that it was not operational? I don't think so. And I didn't know that when I bought stock in this company. I wish I did, because I wouldn't be here. So now I know, and it's a day late for me and my investment, but it's not too late. It's not dead yet, and it doesn't have to die. And the way that you can keep it from dying, and the only way that you can give Vinco Ventures and BBIG a chance to be the successful company that we believe that it can be, would be to take the approach that Judge Williams took, which was, he said, I want to protect the shareholders. We don't need to get into all of the details of that case, but the bottom line driving force of Judge Williams, as I read it from afar, was that he did everything that he did because he thought that he was taking action to protect the shareholders. That's all we're asking. Take some action to protect the shareholders. I'm sorry that I'm not more well-versed in corporate law. I'm sorry that I'm not more well-versed in Nevada procedure. The procedures from court to court differ. Council's talked about service and such. And before, when we first got started, we were serving with a statement saying proof of service. And then afterwards, we saw that the clerk's office would serve everybody just by virtue of us getting filed. Ms. Stein sent me an email, and without getting into all of the minutia of it, the most important part was she asked me two things. Please stop serving my client, and I understand that, now that we know that they have a lawyer. And the second thing that she wanted to say was, I want to get proper service. I'm sorry if I misunderstood, but for instance, in federal court and in other courts that I've practiced in, not this court, when you file a document and the clerk then sends copies of the documents out to everybody that is on the roster, including counsel for both sides, that counts as service in some courts. From what I've heard in this courtroom, it doesn't count as service. So I've been educated, and again, this falls under the concept of the fact that when I'm representing myself, I have a full court client. I'm completely out of my, my home turf. This isn't a criminal case. This isn't a case of constitutional dimension. If it was, I would feel at home. This isn't a California courtroom where I made most of my adult living practicing law. This is a jurisdiction I've never taken the bar in. I've never sought to be admitted to. I've never applied for Pro Hoc VC admission. My only connection with Nevada is I've attended legal seminars here for the NACL and for other things, and I do have a couple of criminal lawyer friends that practice here. You probably know at least Mace Yumplowski. Mace is a very close friend of mine. It's a small world, and Nevada is a very small legal community. I also, unfortunately, know lawyers that have been disgraced in this town. I'm not personally friends with them, and I'm not going to mention names. But bottom line is, nothing would make me happier than to see this company succeed. I know that Mr. Muntz shares that. I know that Mr. Vick shares that. I know that the 1,400 people that signed up for the website that Mr. Vick created share that. The last week when we were here filing papers and everything, I came and Mr. Vick came and we worked, from a hotel room and got papers filed. We met another investor here. His first name is Jared. This investor and his father invested $4 million into this company. And their $4 million investment is almost completely eviscerated. And they're devastated by it. And this young man that I met who convinced his father to invest over $4 million is devastated by the fact that he led his father to a ruinous financial investment. When I met this young man, he was practically in tears over saying, how do I live with myself when I got my father to invest in this company that I really believed was going to be a very, very beneficial investment. And now when I sit down with my father, I feel ashamed. I feel unworthy. And the damage that the board of directors is causing to ordinary men and women and family people and even children. I know one investor who he keeps telling his young son about how this investment is going to be so good for their family. And the young son keeps asking his dad, hey, how's our investment doing, Dad? He's an 8-year-old boy asking, how's our investment doing? Because he can't have the birthday toys that he wants because the family put the money into Vinco. And the money's not there. Meanwhile, we see pictures of Ted flying around Las Vegas in a helicopter at EDC last year. How did he get the helicopter? With our investors' money. These people that are running Vinco see the investors' money as their personal expense account, and they're spending it like drunken sailors. We need your help. It's that simple.
Thank you. So the way it usually works is that the moving party talks and then the opposition, then we have a reply. You had a lot of time, but Ms. Stein did ask for a chance to say something more earlier because the plaintiffs are the moving party. I'll let you have the last word. Ms. Stein?
Thank you, Your Honor. First and foremost, they're mentioning a declaration that's why I was going to ask, we never got. Turns out something was filed at 141 and not served on us again. And
what it was pictures of Vinco showing that non-operations.
well, first of all, they're obviously not evidentiary, and that's one of my issues with everything we've heard. But what they don't understand is we actually closed the offices because of all the threats because of these lawsuits. But I want to go back to what's really more important here. They keep talking about, we heard Mr. Vick talk about he created his own website, that's his job. What they don't talk about is, and we heard now, they have 1,400 investors they're supposedly representing. Again, they do not. This is a 3 plaintiff case that we're dealing with here. And what's important here is they keep talking about these investors, they don't have money. What they don't tell you is that part of his website was to raise money to hire a lawyer. They raised $28,000. We also believe that's where the bond got paid from. And that's paid for them to be here in Las Vegas, that they've been here camping out in front of the court and going to the court. That's what they keep posting about. That's public, Your Honor. So what they don't tell you about is what we're really here for is they're trying to do a shareholder derivative suit. But we also hear, and I don't want to spend a lot of time, but they keep throwing all these allegations. What I think I'm hearing is now they're arguing business judgment rule. They don't like the way the board is operating. It's not a business judgment rule case either, not brought correctly. The bottom line is everything they're arguing for can be handled, and I apologize, at an annual meeting. They have the right to vote. What they don't tell you, and they give a lot of false statements, excuse me, Your Honor.
We need a minute.
No. Thank you. We've heard a lot of allegations thrown out without any evidence, but I'm going to go back to the beginning, what they're not talking about. This company had a hostile takeover. There was, as a result of that, there was a lawsuit. There was a prior CEO, Mr. Colucci, which was part of the lawsuit with Judge Williams. They don't talk about it because during that time, you cannot talk to investors. There's rules. The securities laws are completely different, federal securities laws versus state corporate law, but there's rules on when you have to do that and the ability to talk to shareholders. They don't talk about, they keep, I think we've heard, apparently Mr. Farnsworth is public enemy number one. The problem that they don't have is they've made so many baseless allegations without any evidence. For example, Mr. Law, he never has worked for Zash, but we heard them say that today. And again, they're arguing about independence. They don't talk about Richard Levision, and I apologize if I mispronounce his name, he'll probably kill me later, is independent. They don't talk about the directors are independent. They don't talk about the National Enquirer deal because I don't think they understand it. It's not a done deal, but it's also an income earning deal. Then we hear, and what's very concerning to me, they're like, well, the board doesn't respond to me. When you invest in a public company and you're not a major investor, you're, as you know, even a private company, if you don't own a certain amount of shares and you're not a majority.
Well, if there's a public relations person, no.
Exactly, but when you're in a dark period where you're not allowed to speak to them, you have to abide by that. On top of which, though, we hear about bankruptcy. Well, and I know you know better than most about bankruptcy law, probably better than I do, but Chapter 11 would automatically be delisted, and shareholders are not creditors. They become underneath the creditors. So, again, I kind of surprising what I'm hearing about, and I understand the emotion, but I don't think they understand what's going on with this company. And maybe if they went to the annual meeting to understand that, they could get those certain things, but they all get to vote at the meeting. And by the way, there's 68,000 shareholders, not 1,400 that they supposedly are representing, even though they said they're not. And then they talk about that they can't get records. There's procedures, as you know, under NRS to request corporate records. Those have not been followed. They continue to not follow procedure. Instead, what we're faced with is a 3 rogue plaintiffs who are shareholders, one of which clearly has created his own website, and we don't know why, but it's be creating a thing, getting paid, quite frankly. And what they're doing without evidence is coming to this court saying, give us this because we're not going to get that when they go to the meeting. That's the real issue. And the other thing is, where the statute here, as you know, provides for appointment of receiver, the statutory requirements have to be met or the appointment is void and in excess of the jurisdiction of this court. Well, I get that they're not attorneys or licensed Nevada attorney. The problem we have here is, Your Honor, that in the end, you still have to follow our laws. They've come to this court asking for remedies they're not entitled to in the position as the 3 shareholders. They haven't followed the proper procedures. They haven't properly pled. And again, we would just ask that this court deny their motion for a temporary restraining order and also deny their motion for a receiver.
So I think we need a break. I know that I need a 5-minute break. So I'm gonna ask the plaintiffs if you can, you'll have 15 minutes to use however you want, and I'll ask you to confer about that during the break. It's 3:43. Well, let's be back at 4, please. You guys can sit. And I can't invite anybody to use the restrooms in the back. They haven't opened it up yet for us.
Ed, can you step out and call me, please?
Hey, you can go outside. Okay, let's go outside.
Watch everything? Yeah. Okay, here we go.
I think it's there.